Welcome. I'm Neil. So I'd probably start with an apology. I'm sorry, but I'm a lawyer. Not everyone likes lawyers, but hopefully over the next 20, 30 minutes or so, we can talk about some things that will be of relevance to you. I'm watching your questions as they come through, so feel free to ask. Either Nathaniel can come and ask me questions particularly, but as things go, as the conference goes on and I see questions in the chat, I'll try and answer them as I go along as well. Background game is strong. No, it is actually a taxi. It's simply the quietest place I can find to do this kind of thing. As I say, I'm a lawyer, but I'm probably not your lawyer. I might be. If that might be up your street, my details are at the end. Please feel free to drop me a line. As Nathaniel said, I do internet, telecoms and tech law, so hopefully most of what I work on is going to be relevant to the things that come across your desks and the things you do from day to day. If you are a Twitter person, you're welcome to follow me on Twitter. I'm very happy to chat to people of any background or any interest, whatever you might do. Scan the QR code and that should take you to my Twitter profile. I'm also on Mastodon if you prefer a decentralized or more open source alternative. I'm a lawyer, so I couldn't really start a presentation without some disclaimers. There are lots of you here today, and I'm only an English lawyer. The laws in your country may be completely different to the laws I'm going to talk through today. Hopefully, the themes and the tips I'm going to talk through are generally useful, whatever the specific legal situation is, but please be aware laws do vary between countries. Not only do laws vary, but the right answer to any question is really fact specific. What might be the right answer for one situation won't be for another. So these are general tips rather than tips for any specific situation. I've got about 20 minutes to give some time for questions. So this is a very brief discussion of some issues. I can't give you all the answers you need within the time here. But if you have questions, ask them. If you ask questions and I don't have time to get to them, or you don't think of the question until later, do not hesitate to get in touch. Twitter, Mastodon, email, my email address is at the end. You are more than welcome to come and ask me. What I probably can't do is give you legal advice, but I can try and point you in the right direction or have interesting general discussions. Okay, 20 minutes, 5 tips, let's go. I've broken this down just for the sake of giving some framework for starting a business to 2 areas that are probably most prevalent to developers, whether that's software, web, whatever it might be. The 2 areas I'm going to talk about are firstly, some things to do with contracts, and second, some things to do with copyright. The tips that I'm going to give are likely to be applicable whether you are directly involved in the contract process or in stuff to do with copyright, or whether this is for your general background and your awareness. They also apply whether, certainly for the contract stuff, whether you are a buyer or whether you're a seller. Now, most people are buyers and sellers at the same time, just for different things. But these are general tips and they're likely to apply whichever side you're on. Now, even if you're not involved in the process, perhaps that's done with people with different skills or people who are more senior or managerial level, understanding the basics can still help you, and it can help you ask the right questions, ask sensible questions, ask questions they may not have thought about when it comes to defining the work that you're doing. And also, frankly, the questions that you might ask around a contract are likely to apply when someone asks you to do work within a company as well. You'll understand a bit more what I mean by that when we come to talk to them. But even if you're not involved in like a contracting process with a customer, these things are likely to help you when you work out what you need to do and how you plan your day and deliver things. So as I say, we'll start with contracts. And the aim of a contract, in most cases, is simply to get clarity and certainty. Clarity and certainty about a number of different things, which we'll go on to talk about. But your overall goal is to understand what it is that you have to do, what they have to do, what are your obligations, what are the impact of doing these things, how do you get your money, or how do you pay someone, in sufficient detail, in sufficient clarity, in sufficiently unambiguous language, that if there's a problem, you can turn to the contract and say, yes, this is what I need to do, or this is what I expect of you. Where things go wrong is typically where things are ambiguous, where things aren't clear, where someone didn't think of something and the contract doesn't say what you have to do. Hopefully, in most cases, you're going to be able to talk with them and come up with some sort of reasonable, fair, common sense resolution. And in all the years I've been doing work involving contracts, and that's 15 or 16 years now, I don't think I've had an example of one which has actually gone to a dispute. So while disputes may be high profile, while disputes may be the things that you worry about, if you get your contracts right, if you work with your suppliers or with your customers, you may be able to avoid disputes completely. So with that in mind, let's start. Tip number 1. I've promised you 5 tips and I promise you'll get them. Tip number 1, define the deliverables clearly. So the deliverables, they're the things you have to do. If you're a seller, they're the things that you have to deliver for the customer to be satisfied that you've done your job properly. And if you're the customer, they are the things that you are buying. You want to be specific about what it is that you're buying, what it is that you're selling. And ideally, like objectives or goals, these things should be measurable or accessible. You don't want them to be vague. So to deliver a good enough system, well, good enough for what? Specify in detail what it is that you're selling or what it is that you're buying, so that if someone produces or you've done what you need to do, you can look through and say, yes, I have ticked all these boxes. I have done what's required of me. If you leave it more vague than that, you run the risk of someone going, but that wasn't what I was expecting. Well, okay, that may not be what you were expecting, but the contract says this is what I have to deliver. If you can't be that specific, you do run the risk of someone being upset, whichever side you're on. So in a lot of cases, you'll try and come up with a specification. This is what I'm going to deliver. Now, it may be you need to charge for the development of that specification. It may need to be that sort of, it may be that detailed. You need to do a discovery phase, a piece of work first to work up the specification. You may not just know what you need to do, and you may not be able to work that out for free. That working out what you need to do is a valuable service. If you're going to do that, make your specification as detailed and as unambiguous as possible. Ideally, it's almost a tick list, a list of things that you can go through and say, yep, done that, done that, done that, done that, and it's very clear whether you've done it or not. And attach that to the contract and reference it in the contract. Again, you're trying to get certainty and clarity. What is the process for testing whether what you've done or what you've bought does meet the list of things in the specification? What is the acceptance process? Who has to do what and by when? You don't want to do your work and then find the customer doesn't intend to test it for another 4 or 6 weeks. Equally, if you're the customer, you don't want to find that the work's done, but you're squeezed into 48 hours to do the testing on a really big project. So the timescales that apply will depend on exactly what's being done. But if there are no timescales in there, that starts to be ambiguous, and you go back to that idea of clarity and certainty. Not everything works first time. Sometimes things will need to go back and then redo them. You may think that you've hit the specification, but the client does the testing and says, actually, it doesn't do this. Well, hopefully you've pre-tested it yourself to be confident, but things do come up. What's the process for fixing those? Are you promising that if they spot something that doesn't comply with the specification in the acceptance test process, you'll fix it? That might be reasonable. What you probably don't want to do is find yourself that you're on the hook for fixing it forever. That the customer pops up in 2 years' time and says, do you know that code you wrote, that website you developed? Yeah, it's not running anymore. You probably want to say, well, you accepted it, you tested it, that's now done. I may be able to offer you a service to help you fix it, that's fine, but this isn't something you're getting for free. From a customer point of view, you want to be confident that if you spot a load of defects in something, ideally during your testing period, well, you have a testing period, and that if you spot defects, you're not going to be charged more to fix them. You're not going to be charged more to meet the specification of the service. So try and get it documented as much as you possibly can. Chances are you can't do something on your own. If you're buying something, you certainly can't. You need the other side to do whatever it is that they're producing or developing or selling to you. If you're the The developer, if you're the seller, you may still need the customer's input. They may need to make decisions, and those decisions may impact timescales. If they're too slow, they may impact cost. So write down what is the other side responsible for? What do they have to do, and when? What do they need to provide? So that's tip number one. Define your deliverables clearly. Tip two is all about the money. And you're here for a business. There's nothing wrong with talking about money. If you don't talk about money, something's gone wrong. Now, I will say there's a caveat to that if you're developing free and open source software, then issues around money are perhaps different. But we're thinking here about the scenario where you're perhaps being paid to do some development, or you are buying some development from someone. So money is a perfectly reasonable topic to talk about. Think about the basics. How much are you charging for this work? Is it a fixed price? Is it time and materials where you charge based on how long something takes you or what you need to do for that project? Is it a mix of both, which you might call a capped fee? This is the upper limit, this is the ceiling. You will never charge more than that. But if it actually costs you less in time to do it, you'll charge something lower. What currency are you being paid in? Increasingly, I'm being asked, will I accept cryptocurrency, Bitcoin? Will I accept payment in digital representations or linkages to apes? And I'm quite boring. I prefer just pound sterling transferred to a bank account, thanks. But be specific about it. If they're going to be, or if the other party trades in a different currency, someone has a currency conversion cost. Is that you? Is that them? Are there bank charges applicable for doing an international transfer, for example? Who bears that cost? Presumably, if you're the developer, you want a certain amount of money. And if it costs the customer to transfer that to you, well, they need to pay that on top. If you're the customer, you might have a total budget, and that is all you can spend. You may not have the money for doing extra on top. So think about it and document it. When do you get paid? Now, as a customer, you may not want to spend money in advance. You want the certainty that you're going to get your product before you part with your money. As a developer, it can be very difficult to run everything in arrears. The idea that you're not getting your money until later on. Can you split it? Can you get some in advance and some later? Are there milestone or interim payments as you deliver the project, perhaps on a monthly basis or on a quarterly, or as you just hit certain milestones whenever they happen, rather than waiting for all your money at the end or demanding it all at the beginning? What's the impact of late payment? Now, English law provides an automatic scenario for you to recover the costs of claiming late payment and for interest for late payments. In fact, some automatic fees for late payments. I'm not going to go into the detail of those, but certainly if you're trading under English law, it will be worth familiarizing yourself with the late payments of commercial debts framework. But write about it in your contract. Say, this is what happens. Don't be shy charging it. You can always say the first time, look, I could have charged you this. You were late paying your invoice, but I'm not going to. You can waive it, but be specific. And don't be shy about asking for payment. If you've done the work, you deserve to be paid for it. So ask for your money. And if you need to rely on the late payment clauses, consider doing so. It's not a business if you're selling something and people are just taking it and not paying you for what they paying you the money they should deserve. Sorry, should deserve the money that you've agreed in the contract. Tip 3, intellectual property. This obviously covers a whole load of things, and I'm not going to get into the detail, but we're talking here about particularly copyright in things, possibly patentable innovations, but it's really copyright that I'm thinking of here. You've taken some photographs, produced some audio, designed a website, so you've got some code and some media files, or you've written some software and you've got the source code and the content, the sound recordings, videos, whatever goes into what it is that you're doing. Are you doing it and then giving away the ownership of that? Are you transferring or assigning the ownership of that copyright to the buyer? Or, and if you are, do you need a license back? Do you want a license back so that you can use some of what you've developed for your own purposes? Or are you just giving a license, a permission to the customer to use it, but they don't get to actually own it? And if you're going to develop something and then try and sell it to others, or license it under a free or open source license, you probably don't want to transfer the ownership away because it would stop you from doing that. Chances are, giving a license, the customer will see as less valuable than getting ownership, so you may not get as much money for it. The customer may not care. They may not want ownership. A license, as long as it's a specific license, what the license covers, how long the license lasts, may be just as good as ownership for them. But you need to have these conversations up front and document what the position is. What if you're bringing your own tools to the situation? You've already got some libraries which will do what you need to do. You probably don't want to find you've accidentally given away ownership in those. So be clear about what happens about your own existing intellectual property, your own existing libraries. What happens if in the course of the project you actually develop an enhancement to your own pre-existing work? Who owns the enhancement? And lastly, for this at least, be clear about your use of free and open source software. Some organizations are very happy with it. It speeds up development time. You can use code that loads of others have seen and others have worked on. And if you're doing something in cryptography, rolling your own is probably a really bad idea. But the customer may not be happy with you using free and open source software, or they might be specific about which licenses that you can use. So try and think about it up front. If there's no prohibition in your agreement, you're probably free to do it. But if I were you, I'd be asking that question. And if I were the customer, I'd probably want to know, is my solution going to come with free and open source software in it? And if so, what licenses? I can then go away and think about the implications of that for how I intend to use it. Tip 4, I've promised you 5, so we're getting there. Tip 4 is about your liability, your risks. What if things go wrong? What might it cost you? What might the impact be? So start simple. Work out what your risks are. What is the impact of those? Ideally in financial terms. If X happens, what would this mean to me? What would I have to pay? Think about capping your liability or excluding your liability so that you're not on the hook for absolutely everything. Maybe you've agreed to do a piece of work for £2,000. It's probably not reasonable for you to be on the hook for tens of thousands, hundreds of thousands, or millions of pounds of liability. There are some things you can't exclude, personal injury or death caused by negligence, for example, or liability caused by your own fraud. But there's plenty you can do, particularly in a commercial relationship. Limit the period for bringing claims. Maybe if someone wants to sue under this contract, you want to limit to a year from the date of delivery, a year from the date of performance, 2 years from the end of the term, from the point of termination, whatever it might be. Some sort of dispute resolution process. There has to be an escalation before they can sue you. You could also look at other things, mediation or arbitration, but each of those has its own vagaries and specificities as well. Overall, though, think about and assess your liability. Read your contract. Tip 5, really simple one. Read the contract. Read it twice, things you didn't pick up the first time. Do not just sign it. Do not be told this is standard. Don't just click accept. I mean, seriously, don't do it. Don't. So you can usually negotiate stuff as well. If someone presents you with a set of terms and you don't like them, ask about it. If someone says it's standard, well, everyone says it's standard, so what? The deal needs to work for the specifics of what you're doing here. We never negotiate this. Okay, but if you want the delivery, maybe you need to. I can't pretend that always you'll be able to negotiate everything. I'd love to pretend that you're going to sign up with a service with Amazon or with Microsoft and negotiate the contract with them. Realistically, in 99.99% of cases, you're not. But oftentimes you can, and you need a deal that works for you. You often sometimes see a threat. We'll walk away if you don't sign it. Well, if your supplier's trying to hold you over a barrel like that, or you have a customer threatening you that way before you've even started work, I'd be really worried about what that relationship is going to be like and how the performance of the contract is going to go. Might be time to walk away. There are a couple of books if you want more reading about negotiations, 2 books I particularly like. Getting to Yes, an older book, a little more academic, but a whole load of useful tips and techniques in there. And Never Split the Difference is a more modern book. It's by, I want to say, an FBI hostage negotiator. And it has some really useful practical exercises and examples of how to improve your own posture. Yes, good comment there from Darren. That although I've been talking mainly about sales or procurement contracts here, selling or buying stuff, the same principles work with employment contracts. You can typically negotiate things. I'm conscious that I've probably hit my 20 minutes and I haven't started on copyright yet, but I had no real questions. So unless Kevin or Nathaniel tells me off in the chat, I'm going to carry on going for a few minutes longer. Think about a contract. Think about a template, something that you can give when someone asks you for work. It can make your contracting faster and make it suit your needs, obviously, but if you're unreasonable or unbalanced, they'll probably get people coming and ask you to make changes, and that takes time that you might want to avoid. Be open to amendments to your own template if the deal deserves it. Don't be one of those people who says, but I've got a template, I can't deviate from it, unless that's justified. And if you've got a template that works for you, even if you end up reviewing someone else's contract, you can use your own template to say, well, that's what I would have liked. That's what they've asked for. There's something different here. So it's a useful tool in itself. Okay, so I promised you 5 tips. We're already on tip 7. So let's dive into copyright. I will give you the fastest primer I possibly can. Copyright is a bundle of property rights. They are automatic. You don't have to do anything. You've written your code, you've saved it. Copyright has automatically arisen in that code. And they arise when someone creates what's called in legal terms a work. And copyright works can cover a number of things, and the ones that are probably most relevant to you are literary works, things like a book or a poem, instructions, documentation, software. A database is a literary work. There are dramatic and music and artistic works, songs, musical scores, photos, drawings, videos can be within that. Things that you might use in your projects. A sound recording is a copyright work in itself. So chances are the things that you're doing attract copyright. And the impact of that is that certain rights are reserved to the owner of that copyright. Now, it could be you as the author, or it could be someone else, depending on what you've signed up to. But the owner has certain exclusive rights, and they last for a long time. So if you've written software, a literary work, for example, the copyright lasts for 70 years from the year of the death of the author. In software terms, that's a massively long time. Now, I'm not a huge fan of copyright. I can't believe that 70 years from the end of the year of the death of the author is appropriate. But that's another presentation for another day. So those rights, the things that are reserved to the owner, anyone else who wants to do them needs some kind of permission. And that could either be where the law says you can do this, or you need to get a license from the owner that says you can do it. Now, in any sensible situation, you would try and get that license in writing, and you would want it to be specific. Think back to the contract things. A license and a contract aren't quite the same legally, but a lot of the tips will be absolutely the same for a license. You may have heard about fair use. I can do that without a license. It's fair use. Happy days, great if you're in the USA. Still not brilliant. The scope of fair use is certainly there's greyness around the edges of it, and fair use is a defense. It's a defense which says, yeah, okay, I infringed your copyright, but I have a defense that lets me do that. If you're outside the USA, I'd be far less worried about fair use. So we said about reading your contracts and not just signing. Same with your licenses. Read them carefully. Try and identify problems before you're committed to using, that code or that photograph or whatever it might be. If, like me, you're a fan of free and open source software, just be aware that not all free and open source licenses are interoperable. You may need to work out what you're going to do with the code, and then check that the licenses will interoperate correctly and allow you to do what you want to do. Similarly, not all Creative Commons licenses let you use the covered thing commercially or let you modify it. So if you're looking at a Creative Commons license with an NC in the title, it means it's for non-commercial use only. If the license title has an ND in it, no derivative works. You can't make modifications or changes to it. Kevin has asked, are there any common issues with open source licenses folks often don't realize? Yes, that's a great topic for another presentation, but not one I will be able to cover now. There are a number of things you need to think about if you're using free and open source software. And if I haven't bored you all to tears this year, maybe that's the topic for next year. Avoid the common mistakes. They're easy to make. Lots of people make them, particularly really strong-minded people on the internet will often be in your mentions, in your replies, making these kind of comments. Don't be that person. It's on the internet, so it's in the public domain. It might be in a colloquial sense, but probably not in a legal sense. You can't just take stuff from the internet. Copyright still applies to content that people upload. As long as I reference the source, as long as I cite it, I can do whatever I want with it. It doesn't work like that. Now, citing things can be a requirement for some of the permitted uses under law, but they're still pretty narrow. It's free or open source, so I can use it however I want. No, there's a fair amount of litigation relating to breach of or infringement of free and open source software licenses. Again, you probably don't want to be that person. Hopefully, you could find a good way of solving an infringement, find a way of settling, but don't assume that because it's free and open source, you can use it however you want without consequence. So, tip 10, this is the final one. Know when to bring in an expert. You are, I'm sure, great at what you're doing. You wouldn't be here on a Saturday or watching this recording afterwards if you didn't care about what you do. There are limits to what your knowledge and expertise are. You can't be a master of everything. It's easy to miss something or misunderstand something. Now, taking professional advice can lower your risk and help you make more money. There are upsides to doing it, but it also costs money. Not all projects, not all situations justify money and time spent on legal review. It's not easy to do when you're beginning, but try and work out, is this one of the things that you really need legal review on? What would be the risk if you didn't do it? And then consider talking to an expert. Use the tips that I've given here. Be clear about what is needed. Be clear about the specification for that work. Is it going to be a fixed price? What's the fixed scope that you're going to get? If you can, avoid just paying someone by the hour. What an old-fashioned way of doing things. It's not always possible to avoid that. Sometimes things are so vague and ambiguous that the only way your advisor can do it is say, I can start, but I can't tell you how long it's going to take me. But realistically, they can probably give you a price for a fixed scope. Do your homework. There are loads of people out there asking about, there are loads of people out there offering advice on things. Find someone who can actually help solve the problem that you've got. Ask them, have they done this before? What happened when they did it before? What did they learn from doing it before? You're spending your money, so spend it wisely. So I promised you 5 tips. I've given you 10. You can download the slides from our website or just scan this QR code on your phone and the slides should either start to download automatically or you'll get prompted to do so. Not too many questions have come through at the moment. So if you have them, now's the time. I think there are probably a couple more minutes before we run out. Otherwise, you've got my Twitter details earlier. If you go and download the slides, my email address is on the last slide, so you're very welcome to get in touch and email me about it. Or come and talk with me on, there we go, slides have come back. There we go, there's our website again and my email address. You're very welcome to get in touch. Just say that this is where you, no problem at all, Kevin. This is where you heard of me from, because I try not to get too many emails from randoms about things, but by all means, drop me an email. Talk with me on Twitter, talk with me on Mastodon, and go there. Question, can I go back to the QR code for downloading the slides? There we go. Leave it there.